Thanks everyone for joining. We'll just start in a moment. So good afternoon, everyone, and thank you for joining today's session on the Bonavero discussion group. We'll be hearing from Professor Lena Salaymeh about her paper comparing Islamic and international laws of war. Lena is a British Academy Global Professor at the Oxford School of Global and Area Studies. She's a scholar of law and history, specializing in critical theory. She uses interdisciplinary and critical methods to ask historical, historiographic and jurisprudential questions about Islamic law and Jewish law in the late antique, medieval and modern eras. Her first book, just titled The Beginnings of Islamic Laws, received the American Academy of Religion Award for excellence in the study of religion in the category of textual studies. Responding to Lena's work today will be Professor Patricia Sellers. Patty is a well-known international criminal lawyer who's currently serving as the Special Advisor for Gender for the Office of the Prosecutor of the International Criminal Court in Den Haag, while also teaching on the Oxford Masters in International Human Rights Law, where Patty happens to be enviously popular among students. Patty has previously served as a legal advisor for gender and prosecutor at ICTY and a legal advisor for gender at ICTR. Patty, like Lena, is also a recipient of several awards, including most recently the prestigious Prominent Women in International Law Award by the American Society of International Law. Thank you, Patty. Thank you, Lena, for joining us today, and we look forward to hearing from you both. Thank you also to our online audience for joining us. Please feel free to drop your questions in the Q&A box in the Zoom window anytime. You don't need to wait until the end. We'll pick up on your questions once we commence the Q&A. Lena, may I invite you first to deliver your remarks on your paper, and then we'll turn to Patty to respond before turning to the audience for the Q&A. You have 25 to 30 minutes. Thank you.
Great, thank you. Thank you so much to the Bonavero Institute for the invitation to be here and for organizing this event, and also to Patricia for her comments. So my talk today summarizes an article that was recently published in the American Journal of Comparative Law. In the article, I investigate how contemporary laws of war rationalize civilian deaths by examining two specific legal constructions in warfare: the definitions of civilian and combatant, and the principle of distinction. I focus on two significant parties in contemporary warfare, Al-Qaeda and the US military. And I illustrate that Al-Qaeda diverges from orthodox Islamic law on these two legal issues while remaining within the Islamic legal tradition. To scrutinize the nature of this divergence, I compare Al-Qaeda's legal reasoning to the legal reasoning of the US military. I demonstrate that the US military diverges primarily by rendering civilians as probable combatants. Based on this analysis, I argue that the legal reasoning of Al-Qaeda and other militant groups is coloniality law. So this talk and the article upon which it is based illustrates some heuristics for decolonizing comparative law. Decolonial comparative law is the objective of a research project that I co-lead at the Max Planck Institute for Comparative and Private International Law in Hamburg. In every legal tradition or system, there are groups or institutions that have more power than other groups to generate law or to claim what law should be. Legal orthodoxy refers to the power of some groups to claim authority within a legal tradition or system. Non-orthodox groups within a tradition often allege that they apply or only slightly modify orthodox law in order to legitimate their legal opinions or acts. This is why militant Islamist groups engage with and cite to orthodox medieval Islamic laws of war. They attempt to justify their acts as orthodox. Thus, to understand their legal arguments, it is necessary to have a basic understanding of orthodox Islamic legal ideas on warfare. Correspondingly, the US government identifies itself as part of the modern international legal system. the US military engages with, even when explicitly overruling, orthodox modern international laws of armed conflict in order to justify its war practices. The consensus of orthodox medieval Muslim jurists is that women and minors may not be targeted in warfare unless they participate in fighting. Orthodox jurists cite a prophetic tradition report that delineates civilians as women, children, the elderly, clergy, and hired workers. Many Orthodox jurists extended non-combatant immunity to the disabled and the mentally ill. By and large, Orthodox Muslim jurists permitted so-called collateral damage killing of civilians so long as they are not targeted intentionally. In short, Orthodox medieval Islamic legal texts indicate two minimum guidelines. The category of civilians consists of non-combatants, who are usually women and children, and the intentional targeting of civilians is prohibited. Orthodox sources of modern international laws of armed conflict include international agreements and customary practices. The Geneva Conventions and their additional protocols are the key legal documents outlining Orthodox international laws of war. Article 48 of the Geneva Convention, Protocol 1, requires all parties to distinguish civilians as persons who are not members of armed forces, militias, and those who openly use arms. Article 50 also declares, quote, in case on warfare based on the principle of distinction. Both Orthodox medieval Islamic law and Orthodox modern international law distinguish civilians and combatants based on some criteria of conduct and promote a principle of distinction in order to prevent civilian casualties. Despite being based on different sources of law and having entirely distinct histories, Orthodox medieval Islamic law and Orthodox modern international law share a basic assumption that civilians are those who do not engage in combat and that they should not be targeted in warfare. Orthodox legal actors make similar claims about the US military and Al-Qaeda, that they are so-called heretics, violating legal orthodoxy, that they are not producing law, but rather political rhetoric, that they are political rather than legal actors, that their statements are post facto justifications of their war practices. In both cases, these assertions romanticize Orthodox law without justifying why these legal perspectives should be considered outside the Islamic legal tradition or outside the international legal system. Branding Al-Qaeda as extremists or bad Muslims reinforces a colonial politics of differentiating between good and bad Muslims. Likewise, labeling the US as a bully state obscures the international legal system's close connection to colonialism. Al-Qaeda diverges from Orthodox Islamic law, just as the US military diverges from modern Orthodox international law. So let me explain this more precisely. Al-Qaeda's legal claims diverge from Orthodox Islamic legal definitions of civilians and the principle of distinction. First, Al-Qaeda diverges from Orthodox Islamic law by rejecting the category of civilians. A 1998 statement published by the World Islamic Front, an Al-Qaeda affiliate organization, calls for targeting US military and civilians without offering any Islamic legal precedents for that targeting. An open letter authored by bin Laden in 2002 alleges that US citizens support the US military through representative governance and the paying of taxes. By enlarging the notion of indirect support to include financial and political support for US colonialism, Al-Qaeda effectively expands the definition of combatant to include any US citizen. Second, Al-Qaeda departs from Orthodox Islamic law by dismissing the prohibition on intentionally killing civilians. Al-Qaeda bases its position on its enemies' war practices, repeatedly declaring that the US targets Muslim civilians. Al-Qaeda claimed that the principle of reciprocity in warfare supersedes the Orthodox principle of distinction. So the idea of reciprocity in targeting civilians does not appear to have historical precedent in pre-modern Orthodox Islamic law. By comparison, the US government outlines some of its laws of war in the Department of Defense Law of War Manual. The manual diverges from Orthodox international law's definition of civilian and principle of distinction, specifically the target verification requirement. First, the manual departs from Orthodox international legal categorization of civilian by expanding the category of combatants to include those A, not involved in essential combat support, and B, not currently involved in combat. So the manual interprets the orthodox international legal principle of, quote, taking a direct part in hostilities, end quote, to include, quote, any effective and substantial contribution to the ability to conduct or sustain combat operations, end quote. As international lawyers have emphasized, this contradicts orthodox international law. An additional expansion of the combatant category is evident in the manual's temporal expansion of a civilian's loss of immunity. Basically, the manual permits targeting individuals based on past conduct and anticipated future conduct. In effect, the manual replaces the conventional conduct test with a status determination. In addition, the manual differs from orthodox international legal principles of target verification, which requires verifying combatant status. The manual gives broad permission for the US military to attack an individual who they merely suspect is a combatant. The manual justifies its unorthodox target verification policy by referring to the realities of war. So I've presented two parallel frameworks demonstrating how Al-Qaeda evades orthodox Islamic law and how the US military avoids orthodox international law. However, orthodox legal positions are not as straightforward as orthodox legal actors claim them to be. Both orthodox Islamic law and orthodox international law acknowledge some form of reciprocity as a legal justification in warfare. Nonetheless, what precisely is inside or outside of legal orthodoxy is both indefinite and shifting. The key issue is not if Al-Qaeda or the US military are orthodox legal actors, but rather what the prevalent portrayal of them as heretical means. Al-Qaeda and the US military are characterized as heretical within specific legal traditions, Islamic and secular. So I want to turn now to exploring their place in these traditions. The accusation of heresy diverts attention away from the more profound question of the relationship between the so-called heretical group and the legal tradition. Neither Islamic law nor secular law has essential features. Nonetheless, at a macro level, Islamic law and secular law both have orientations that make them distinct from other legal traditions or systems. Indeed, it is through comparative legal analysis that we can identify the logics of particular legal traditions as depicted on the slide. The Islamic legal tradition is the multivocal outcome of Muslims who study and interpret Islamic scriptural sources in an attempt to comprehend the abstract concept of Islamic divine law. In the Islamic legal tradition, tradition is the centripetal force. By comparison, secular law is a product of secular states and institutions. In the secular legal tradition, the modern state is the centripetal force. Notably, the identity of a legal actor does not determine the content of her legal opinions. The gap between orthodox Islamic law and contemporary militant Islamist decrees is the source of much confusion, angst, and debate, and generally two questions are conflated. The first is, are militant Islamists Muslims? And the second is the legal reason of militant Islamist groups part of the Islamic tradition? So first, from a scholarly perspective, anyone who identifies as Muslim is Muslim because being Muslim does not entail any essential belief or practice. Thus, militant Islamists are Muslims so long as they identify themselves as such. While militant Islamists may be heretical from the perspective of orthodox groups, that does not mean that they are not Muslim. So from a historical perspective, the claim that militant Islamist groups are unorthodox is not meaningful. Orthodoxy forms through a gradual historical process. It changes, and it is not the essence of any tradition. Thus, these militant Islamist groups may be changing Islamic orthodoxy. Among non-Muslims, the definitional context often reflects problematic notions of authenticity, such as the militant groups are not real Muslims, or Islamophobia, meaning militant groups represent true Islam. Nevertheless, because individuals and groups have multiple identities, not everything a Muslim does is Islamic. Second, the legal reasoning of militant Islamist groups may be Islamic, even if it is unorthodox. So the wishful claim that militant Islamist groups are not generating Islamic law is simply false. The Islamic tradition has within it precedents and principles that can be interpreted as legitimating militant practices. Furthermore, medieval Orthodox Muslim jurists decontextualize Islamic precedents and doctrines by insufficiently considering historical conditions in ways that are analogous to contemporary militant Islamist groups. So by way of example, in chapter 2 of my book, I illustrated how medieval Orthodox Muslim jurists permitted the execution of war prisoners despite the strong late antique historical evidence of prohibition of execution of war prisoners. So Orthodox Muslims may find militant Islamist interpretations unconvincing or disturbing, but that does not mean that they are not Islamic. Nonetheless, Islamic law, like any other legal tradition, is hybrid. So to begin identifying the liminal space wherein contemporary Islamic law ends and non-Islamic law begins, which is a fuzzy space, we need to engage in comparisons with contemporaneous legal traditions. So let's look at the secular legal tradition. As previously noted among international law specialists, it is commonplace for the war practices of the US government to be described as violations or misapplications of orthodox international law. Yet US laws of war are actually consistent with the 19th century beginnings of the modern laws of war. First, modern international law reflects a hierarchy of nation states, with colonial states having the de facto power to dictate and to modify international law. The US's construction of the category of unlawful enemy belligerent is an extension of international law's hierarchical differentiation between state and non-state conflicts. Second, international law does not fully protect colonized peoples under the laws of war. Just as 19th century international legal actors sought to exclude non-state anti-colonial groups from international legal protections, the US excludes non-state anti-colonial groups from international humanitarian law. So the US classification of unlawful enemy belligerent functions to deny non-state groups international legal protections, rather than to deal with any peculiarities of non-state groups. Third, international laws of war were spread through violent colonialism, and the US is disseminating its interpretation of the categories of civilian and combatant through its neo-colonial military interventions. Notably, the modern international legal system is secular because it is built around secular institutions and secular treaties. Moreover, the primary form of international legal enforcement is secular power. A significant aspect of the international legal system is differentiating between civilized states and uncivilized states, which is analogous to colonizer states and colonized states. The modern international legal system is also secular at the substantive level. So let me briefly explain what I mean. The modern international legal system conforms to and promotes secular law. Secular law does not have an essential characteristic, and it's not homogeneous. There is significant geographic diversity among secular states and temporal changes in the secular legal tradition. There are, of course, variations in the European, North American, and non-Western traditions of secularism. Secular states may have an established religion, no established religion, or be overtly anti-religion. Nonetheless, when we view secular law through non-Eurocentric and historical perspectives, the particularities become less discernible, and a broad pattern emerges. Secular law is not neutral or universalist because it was shaped by its historical beginnings in early modern Western Europe. Despite the geographic and temporal particularities of secular law, there are identifiable logics in secular legalism and secular state practices. So comparing the legal reasoning of al-Qaeda and that of the US military reveals a parallel structure. Al-Qaeda and the US government share a simple three-step legal reasoning process. First, the identification of war as an obligatory form of self-defense because of exigent circumstances. Second, the claim that combatants is a broader category than previously or conventionally understood because of the enemy's war practices. Third, the avoidance of orthodox legal definitions of civilians. The first step in this legal reasoning process is effectively a declaration that exigent circumstances require deviation from orthodox law. Overall, the three-step reasoning process results in comparable conclusions. Al-Qaeda's legal decree calls for the killing of Americans wherever they may be and regardless of their civilian status. Implementing that proclamation results in disregarding civilian status. The US government similarly calls for the killing of Al-Qaeda and their allies wherever they may be, and implementing that proclamation results in disregarding probable civilian status and rationalizing collateral civilian casualties. Al-Qaeda claims that US targeting of civilians demands reciprocity, and the US military claims that the reality of warfare overrules the principle of distinguishing between civilians and combatants. So based on this analysis, the banal argument is to claim that Al-Qaeda and the US military share a similar disregard for orthodox laws, or the rule of law. My argument goes further. I propose that Al-Qaeda and the US military share legal reasoning, and more precisely, Al-Qaeda and the US military share the same secular legal reasoning. Rather than being heretical, I propose that the legal reasoning of Al-Qaeda and of the US military is secular. I contend that their shared three-step reasoning process is secular because it conforms to three corresponding aspects of secular law. First, secular law is law of the modern nation state, which means that the state is a centripetal force and law is produced in service of the state. In turn, a significant objective of the state's legal system is maintaining the state's monopoly on the use of violence against its existential enemy. Second, secular law delineates ethics rather than vice versa. 19th century international legal actors alleged that combatant applied only to colonial soldiers, not resistors of colonialism. Likewise, the US military alleges that combatant applies to its soldiers, not resistors of its neocolonialism. A secular legal logic determines who will be considered a combatant based on the classification of the enemy, rather than considering the ethical issue of who is a civilian and how they will be protected. Ethics is secondary to the state's objectives. Third, secular law constructs religious law as a legal code, such that orthodox definitions of civilians may be superseded by the state's objectives. That is, the state only applies orthodox law if it conforms to the state's interests. So from the perspective of the state at war and under so-called exigent circumstances, there are no civilians, there are only probable combatants. Al-Qaeda and the US military point to each other's warfare practices as legitimation of their unorthodox legal positions. In the contemporary moment, militant Islamist groups and neocolonial states use each other to justify their violence, particularly their legal rhetoric surrounding violence. This symbiosis serves both states and militant groups by redeeming secular violence as a form of self-defense and by legitimating militant violence as sanctioned by so-called religion. Yet when militant Islamist groups point to religion as justifying their acts, they are not pointing to historical traditions, but rather to the contemporary secular construction of religion. Indeed, Al-Qaeda and the US military share the same understanding of religion. Coloniality is a totalizing and universalizing mode of thought and being that underlies colonialism. The modern international legal system initially applied its law to states and their armies, not to the colonized peoples who lacked both states and armies. 19th century international legal actors differentiated between war and anti-colonial resistance in order to justify colonialism. Just as differentiating between warfare and anti-colonial violence served colonialism, distinguishing between war and armed conflicts with non-state groups frequently serves neocolonialism. That is, states classify their violence as war or not war based on their interests rather than any substantive difference in the use of violence. More importantly, the colonial distinction between civilized and uncivilized resonates in contemporary differentiations between good and bad states or between Western and non-Western states. Interstate armed conflicts and armed conflicts between states and non-states groups have the same implications for civilians. Both meet a political and sociological experience of war. Neocolonial military interventions constitute wars against civilian populations. Thus, the notion of terrorism reinforces colonial difference and thereby operates as a means of legitimating colonial rationalization of civilian targeting. That is, terrorism is part of the logic of colonial legal reasoning. Coloniality generates a logic of extermination and dispossession. More specifically, coloniality invented a rationalization of civilian targeting that is premised on colonial difference. In our particular historical moment, it is possible to identify how certain expressions of contemporary Islamic law use the legal reasoning of coloniality. But at some point in the future, it may be impossible to differentiate Islamic law from the law of coloniality. I hope that it is clear that I oppose attempts to reclaim or rediscover true or good Islamic, international, or US laws of warfare. I do not have a false expectation that human rights or the rule of law can somehow prevent the excessive use of violence in war. Legal actors instrumentalize law. As an alternative to simplistic apologetics, I analyze the legal arguments that are marshaled to justify the killing of civilians. Al-Qaeda and the US military use analogous forms of violence, they identify similar targets, and they offer comparable legal justifications for their use of force. When it comes to warfare, the US government does not appear to be more constrained by human rights or the rule of law than the militant groups that they claim to be targeting. The three-step legal reasoning process I outlined is a colonial logic that transforms civilians into probable combatants and rationalizes the recklessly negligent killing of civilians. Both Al-Qaeda and the US military do not define who is a civilian in positive terms. The legal question that is systematically ignored is, when does the legal obligation to save a civilian life outweigh the legal permission to kill a combatant? Thank you.
Thanks so much, Lena. I really appreciate it. Patricia, may I invite you now for 15 minutes to deliver the remarks, and you'll have another 10 minutes to respond to Pati's comments, and then we'll turn to the Q&A. Thanks.
Okay, thank you very much, Professor Salaymeh. As I've already addressed you prior to the recording, that I very much enjoyed your article. And I do have to say that it was intricately intriguing because it really made us put an exposition together, juxtaposing what is secular and what is non-orthodox from two sides, from the sides of Al-Qaeda and from the sides of the United States. And I'm saying the United States as specifically intended, but also as a substitute for the coalition forces. I'm saying it as it would apply to other forces that joined, in quotes, the US effort. What I do want to say is that we have to look at your definition of civilian and understand that we're talking almost as individualized civilians and not as civilian population, not in the phrases of international humanitarian law, but in particular international criminal law, that really talks about the civilian population. So I just want to step back a second to differentiate those two, because those concepts really derive from centuries of the practice of, in quotes, the art of law throughout every geographical section of the world. So why is the civilian population, using that term, even though it might be pre-civilian in regard to the definitions that you've given, why should we even pay attention to this civilian population? Isn't it true that we have political leaders? We might have, next to the political leaders in the rungs of society, religious leaders, and then we have the warrior class. And the civilian population, individualized or collectivized, basically comes under both of those classes, the warring classes, the religious classes, and the political classes. The concept of civilian population and civilian predates almost to when we were placing different strata of society, different rungs of society, such as we would have an agricultural sector, we might have a scholarly sector, and here, yes, I am talking about you and us at Oxford. We might have the sector that deals with women and children. We might have the trade sector. And it is true that different legal regimes that related to armed conflict, whether they be from the Japanese tradition, the Islamic tradition, the canon tradition of the Roman Catholic Church, or the European tradition, did want to protect these different rungs of society during armed conflict. Armed conflict was not supposed to take place geographically necessarily in their spaces, nor target them. And you have to ask yourself, well, why do we have this rationale? From whence comes even the rationale that the civilian population is not part of armed conflict? Well, part of it comes from the point of view of the military force and the political force that guides the military force. We have these military actions when there's been a political impasse. So therefore, the protection of civilians and the civilian population was so that this society that was mainly inhabited by civilians would continue to exist so that the winner could overtake, reclaim, or reinstitute the state or the society closest to as it was whenever they won the war. So therefore, you had laws against not completely destroying the other society, meaning its civilian population, so that when you won your military objectives, that society would be intact enough so that it could be colonized, it could be occupied, it could continue to run under your new political regime, or the old political regime would maintain control. And I think that that's an important thing to understand of why even this issue of how each side looks at civilians or civilian populations is very pertinent. As Professor Salaymeh has said, as she points out, we have to understand that civilians are basically now being viewed through how large we can define non-combatants, or how large can we define these really new terminologies, privileged enemy combatants or non-privileged enemy combatants, is a way of reflecting in the mirror back at what civilian means and doesn't mean. I particularly was interested of how you pointed out that at one time, not claiming the civilian population or killing the civilian population was a way to repopulate the slave population in certain situations where sometimes wars were basically to repopulate the slave population that might have died through attrition or might have died through health and disease. So there are rationales in why the civilian population, civilians, are protected. Another thing I'd like to say, as we move to this modern terminology of civilians, and we went through presumed innocence or the inhabitants of a country, you can see this in the Libra Code of 1865, the terminology is more so the inhabitants of occupied territories or inhabitants. So as we're moving toward this modern terminology and kind of easing up on these words such as civilians, that as this was developed, there were exclusions as to who could be protected under these terminologies. And as was correctly underscored, we see that colonial wars excluded civilians whoever colonial people. And under religious wars, civilians, or what our concept of civilians were excluded because they were of another religion. And here I'm talking about whether it's the religious wars of Europe or the modern religious wars. I would just ask you to ask Henry VIII. They said who was Catholic, or who would follow the papal states, and who was Protestant, not are you part of the civilian population. And even at that point in time, are you part of the religious elite, which was a civilian subset of a civilian population? Well, they were among the first to be slaughtered. So our legal terminology in defining what it is to be civilian, what it is to be a civilian population, in some ways is very recent. In some ways it comes to us in the end of the 19th century. Certainly it seems to be reiterated, if not integrated, into the 20th century understanding of what would be international humanitarian law, whether it's from the Islamic population, Islamic legal tradition, or from what you're referring to as the secular or the international legal tradition. With its inherent contradictions, I will underscore colonial peoples, in particularly the Amerindian native populations of the Americas. Just ask Spain and then ask Mexico, where any of the Amerindian population first inquired as to, are you a civilian? Are you part of a civilian population or not? So it served a purpose, having this terminology, and the contradictions or the exceptions of this terminology also served a purpose. They served the purpose of conquest, they served the purpose of enslavement, but in addition to that, they served the purpose of really redefining who was and who was not the combatant. And since much of Islamic legal tradition and as you refer to the secular international humanitarian law tradition, really relies upon the protection of the combatant. So it's important to understand who is a combatant and how to distinguish this combatant from, in quotes, non-civilians. I want to divert just a bit because I think another one of your underlying theories, in order to understand what I call your intriguing complexities, is really to sit with the thought that much of international law, much of international humanitarian law, and certainly international criminal law, has what you refer to as this modernity, coloniality. It is in service of the modern state that has its roots in its colonial experience, not just, as we refer to usually geographically, of states that have been colonized, and now we politely say, are they in a post-colonial phase? I think you're making us look at the colonizer and saying that they remain in a modernity, coloniality existence or phase, because they would not be who they are not who they are, they will not be who they are without having had their experiences of coloniality or being a colonial, part of a colonial empire. And I wanted to bring an example of that from a different point of view of international human rights law, international criminal law, is the 1926 Slavery Convention. When it was drafted and when it was ratified, it's important to understand that by 1926, European-derived slavery had basically ended, meaning slavery within the Americas and slavery within the Caribbean was legally, at that time, it had been abolished. But still there was, in quotes, a need from the European powers' point of view, although other countries did participate in the convention, to have a convention that outlawed slavery, although it had been outlawed. And one has to ask why, because it was a very important time period when many of the European powers were now colonial powers. And they wanted to distinguish in their labor workforces in their colonies between labor and slavery. And so in places such as in Africa and in Asia, And in particularly, those places were newly colonized within the past 30 to 50 years, but in particularly in places where the colonial regime had continued for hundreds of years, such as in the Caribbean, they had to distinguish from the continuation of enslavement to now moving toward a new economic system of labor, which the ILO quickly said, well, that might be forced labor. So within some of our most lauded international treaties, we have to see that they are at times propelled, rooted in, or contest, or to a certain extent remain being the exceptions of the coloniality projects of European states. And then I would just like to get back to issues of the non-state actor. And you have underscored the position of the non-state actor in relationship to international law. It's been quite lucid, quite succinct. We certainly understand that from your point of view, the non-state actor in legal terminologies is the rebel, the terrorist, or maybe the criminal. And that is legal terminologies that we usually reserve for national law. And it's important why we reserve them for national law, because the rebel, the terrorist, or the criminal can be incarcerated, can be executed under the national state, can be seen as the outlier within any national jurisdiction. And that is probably the reason why it took so long for within the Geneva Conventions of 1948 to bring forward just that one provision of Common Article 3. Common Article 3 is where we finally recognize to a certain extent that the non-state actor has a role in non-international armed conflict. Well, it seems to be something that's so banal and so ordinary that you would wonder, why did the nation states, as you say, the state-centric, the centrifuge of the state regime, take so long just to get Common Article 3 on the books? And Common Article 3, if I can just remind you, it really seems as if it addresses the other terminology, the civilian. It seems to protect and address who is outside of combat, who is hors de combat, as if we'll slightly extend now in our non-international armed conflicts, that little section of population of people who are outside of combat, the protection of some of the safeguards of persons in international armed conflict. But at the same time, simultaneously, it makes sure that the non-state actor is not recognized as any state body just by recognizing the civilian person out of combat. So here again, we have this kind of duality of making sure that we disempower the non-state actor while making the exception for what we'll now term a type of civilian, those who are out of combat during non-international armed conflict. And the question might be, is this a reason that we need to rethink this ideal of war? Because the United States and Al-Qaeda, don't we really have a state and a non-state actor? Don't we really have some people that are outside of combat, if we just want to use the non-international armed conflict paradigm, absent these questions of geography and locality? And then I just want to conclude with two other observations. And that goes again to this question of understanding the exceptionalism of the non-state actor, but also the weight that the colonial project still brings today. That it took until Additional Protocol 1 to include colonial wars into international armed conflict. Very much like the Slavery Convention, most colonial wars, or I want to say that 20th century period of contested militant phase of colonial wars, had passed. So once again, we see international law responding to an issue that has been resolved by violence. Many of the continuing trust territories and colonial regimes that are quite evident today are not sitting in the midst of military conflict. And then the last example that I would like to offer for that is the current crime of aggression that has just entered into the Rome Statute of the International Criminal Court. As many know, that the structure of the crime of aggression eliminates the non-state actor from ever being a potential perpetrator of the crime of aggression. Now, one could ask, well, are we finally protecting the non-state actor? So the non-state actor can never be charged with you said about going into war. Is that a protection, or is this another way that delegitimizes any status that the non-state actor could have, particularly under a new law, under a law where the states themselves are concerned about ever being seen as aggressors to war? Do they not want to put themselves in any way in danger by reacting to the non-state actor, and the non-state actor themselves cannot be a perpetrator? Or is it just a continuation of a colonial project of disempowering those who are not in that state centrifugic view that you've given us? So those are the remarks that I have. And I think that there's some questions embedded within them. I've asked about continuity, about religion in and of itself in terms of civilians. So I will stop right there. Thank you very much.
Thanks, Patti. Lena, I wonder if you'd like to take about 10-15 minutes to respond to that, and perhaps if you'd like to pose a question back or clarification back to Patti. And just a reminder to our audience, if you have a question, just post it along in the Q&A box in the Zoom window, and we'll take it from there. Thanks so much. Lena, over to you.
Well, first, thank you so much, Professor Sellers, for these comments. I think it was very, very interesting to sort of hear you reflecting and also engaging and probing the paper. So I think that you were very right, of course, to point out the broad macro historical story that I didn't fully tell either in the presentation or really in the article about the way that war changes and the way in which legal ideas about warfare change from the pre-modern to the modern era. And you correctly pointed out that the modern invention of the category of civilian is a reflection of a particular modern legal situation and modern practices of warfare. Because of course, in the pre-modern text, there wasn't one category of civilian, there were categories of people who should not be targeted. And it was based, of course, on a conduct test, the idea being that anyone who doesn't participate in hostilities shouldn't be targeted. And there was an underlying assumption that the people who participate in hostilities are basically men, able-bodied men over the age of puberty. But women and children would lose their protected status as civilians if they participated in hostilities. So at least in the Islamic legal tradition, the conduct test is very, very clear. The presumption is that a combatant is somebody who's actually participating in combat. And in the modern era, there's a different set of criteria that are used to define who a combatant is. And it's actually based on the conduct of the combatant rather than the conduct of the civilian. And so you're totally correct that this is about a dialogical way of defining things. And what takes the lead in the modern era is the definition of a combatant. And so then the definition of civilian becomes sort of like the negative, the non-combatant, rather than a positive sort of category. So it is important to just sort of recognize that there's a lot more that can be said about the historical transformations in warfare and legal ideas about warfare that I didn't get into totally in terms of details. One of the other issues, obviously, is the professionalization of the military, because in the pre-modern context, you did have armies, but usually soldiers were people who had other jobs and they weren't full-time soldiers all the year round, right? Like they did other things, and then when there was a battle, they would, take up arms and go fight. But now we actually have people whose job it is to be parts of militaries. So obviously this is a huge transformation between the pre-modern and the modern era, and the professionalization of the military then affects how combatants are understood and the legal categories around them. So it's true that there was a rationale in the pre-modern era for potentially not targeting civilians, which is that they can be, as you pointed out correctly, used as enslaved people, so they can be used for labor purposes. This didn't always work out the way that you would expect, because as I've written about, when it came to prisoners of war, they were usually ransomed or enslaved. And yet there were jurists who thought that sometimes they should be executed. So you can see that even in the pre-modern context, it was about instrumentalizing the situation and figuring out what was the best strategy. And sometimes prisoners of war were thought to be too dangerous. And so the idea was to execute them so that they wouldn't be in a situation where they could then rebel. But in any case, I think that the broad issues about the practices of warfare and the terminologies and how they change is really important, as is, of course, the history of colonialism, because the basic premise of decolonial theory is that the modern era begins with colonialism in South America and with the genocide of 50 to 60 million indigenous people in South America. And the point from the perspective of decolonial theorists is for us to always be thinking, when we use that category modern, not of all sorts of positive, progressive things that we like to associate with the modern era, but also with the extreme violence, the forms of ethnic cleansing and colonialism and enslavement that went along with the so-called modern period. And so when I use modern and modernity, I actually don't use it as a term that means a status of development or progress or any kind of, in any sort of unilinear story about how human evolvement led to modernity in some kind of positive way. I really just use it as a block of time. And I think it's very important to sort of understand it as that, and to make sure that the association with modern and colonial is very clear. So that now then we, as you pointed out, can understand that modern international law is in service of the modern nation state. We know that the basic unit in modern international legal thinking is the nation state. It's not that international law somehow thinks about the international community outside of that. There's been lots of work on issues like transnational NGOs and international kinds of groups that don't work within specific nation states, but the basic building blocks of how international law functions is through the nation state, which means that people who want to resist their nation states, people who want to rebel against authoritarian regimes, people who want to overthrow particular regimes, people who want to fight back against colonialism. These are the non-state actors that effectively can be erased by the discourse of modern international law, because there isn't a sufficient space for them to be actors of their own agency. I really, really liked your line that international law responds to matters that have already been fought over, that have already been sort of violently dealt with. And I couldn't agree more. Modern, that is basically what modern international law does. In terms of the continuity, there is continuity, there's also discontinuity. I think it's important to see both of them functioning together in terms of how pre-modern legal concepts get placed into modern international law, and there's a presumption that these are continuations of previous practices, but there's such a radical transformation of the context and the abilities of war, of combatants, for example, that there is also quite a bit of discontinuity. But in my own kind of historical understandings, I try to look at both and try to balance them out. In terms specifically of category of religion, this would be a completely other topic, and it can get very complicated. But I don't use the category of religion in the pre-modern era. Religion, as far as I'm concerned, is a modern secular construct. It's defined by secular law, and that was actually the topic of my previous Bonavero talk. So we won't sort of go into that now, but I would put a lot of suspicion around the use of the category religion, because religion, like the categories of gender, race, and ethnicity, are categories that are very significant to colonial logics, and that colonialism defined in very particular ways. So just as we should recognize that race and gender were transformed under colonialism, that they were constructed in a particular way, and that those constructions actually have very disadvantageous kind of results for colonized peoples, we also need to know that religion plays a similar kind of role. Religion was used in order to divide and conquer colonized peoples, and it plays a role in the continuous kind of neo-colonial projects and neo-colonial power. So sectarianism and the classification of particular groups as religious groups or militant groups as religious groups is itself part of a colonial logic. And I think I'll stop there and take more questions so that we can open it up a bit. Thank you so much.
Thanks so much, Lena. Thanks so much for your remarks. It's a really refreshing and nourishing take on international law, and really appreciate hearing from you about radical ways of thinking about international law as really just serving modern nation states today. So thank you for those. We have